Welcome to the Law Simplified's SQE Prep for Dispute Resolution. I'm your instructor, Shaveen Bandarnayaka. This comprehensive program was designed to help you ace your solicitor's qualifying examinations. I hope you enjoy this course, but without much further ado, let's begin. In terms of England and Wales, when we say dispute resolution, right, and when we try to connect that and collate that to litigation, one important thing that you need to understand, and you would have seen this in the legal systems module as well, is that when it comes to the civil justice process, specifically the civil justice process, you have an important personality and a report called the Wolf Report, which was essentially provided by Lord Wolf. So his task, he was tasked basically with looking at the civil justice process, identifying the pain points, and then essentially providing a solution based on what they researched and discovered. So the two main things that he discovered was the fact that there was immense delay and therefore it was very costly. So as a result, in 1998, originally in the 80s, but then later in 1998, they developed what were called the Civil Procedure Rules, the CPR of 98, which we will go through in detail later on, in an attempt to try and mitigate cost and delay. But one major recommendation his committee made was to try and keep people away from court as much as possible. So essentially to promote alternative dispute resolution techniques, such as mediation and arbitration. This is reflected heavily in the dispute resolution module, because what you will see for about 2/3 of this module is everything that the court and the government tries to do to prevent people from coming to court. So even when a person starts proceedings, there are multiple stages that have been set in place, several milestones set in place to prevent people from pursuing towards trial. They're simply being told an option to try and either settle or to admit fault and then pay partially and things like that. And you see this constantly. The reason why I mention this is, as you will see here as well, in terms of litigation in England and Wales, as much as we are going to discuss commercial litigation, we also look at different stages of mediation and arbitration as well, right? Alternative dispute resolution mechanisms. Now, each of these forms, now overall in terms of an umbrella, your entire subject is broken into these three. So every single discussion that we will have predominantly will revolve around commercial litigation, but at certain stages, we'll also talk about mediation and arbitration. So in terms of scope, this is all that we will talk about: commercial litigation, mediation, and or arbitration. Yeah. Are we good? Shall I proceed?
Yeah.
Okay. Now, the first thing that we need to do is to understand what these three things are and what pros and cons are there. The reason why is, as an undercurrent for every single subject, there is a component of advice that the SRA expects a solicitor to provide to their clients, to the litigants themselves. So the knowledge of each individual type of form of litigation is paramount in order to try and explain to a client which way to go based on their individual circumstance. So to begin with, the most common form of dispute resolution, the one that everyone wants to go with, is to file a case, commercial litigation, right? To forget about any other form of dispute resolution and to simply, I have been wronged, I want to go to court and I want to get redress. I want to be told that I'm right and I want to get paid for it. That is essentially the first mindset. So commercial litigation, because of that, is what the English legal system is built on, because it is by and large the only form of service rendering that the judicial system provides when it comes to civil claims. Predominantly, while the appellate court system is also available, when we talk about commercial dispute resolution, you're looking at either the county courts or the Queen's Bench Division of the High Court. Now, these are the predominant places that you would go to when there is a dispute that you are trying to litigate. Each individual court and how exactly they are utilized, we will look at later on. But to put it very simply, to give you a little bit of an introduction, the selection of court is really based on the value of the claim. We will look at later based on what the claimant is asking for, what he's seeking, depending on the subject matter, whether it's contract, whether it's tort, whether it's family law, and the amount that they're claiming. Is it less than £100,000 or more than £100,000? That is where the selection process comes in. But you don't need to worry about it at this stage. I'm just giving you a little bit of context. As you would know, it's extremely expensive. It is quite slow. And the nature of this is once you start litigating, you will no longer be friends. Neither the parties nor not the lawyers. The lawyers will anyway be friends. As I've often said, the only winners in a case are the lawyers, not the parties. But essentially, this disadvantage is something, these disadvantages rather are something that cascades jurisdiction. It is still a problem wherever you go. It's expensive, it's slow, and it's antagonistic. Now, it is this reason why, in terms of Lord Wolf and his committee, that have tried to flesh out and promote different alternative methods of dispute resolution, especially if it is something that relates to a very minor or familial nature. Think of it like, for example, when we do contract law, you will notice we go through a module called formative requirements, intention to create legal relations. When it's a small matter before a court, which perhaps has relatives, friends, or family involved, it's very rare that a court of law will entertain that litigation. They will essentially send people to either mediation or, in rare instances, even arbitration. So that being said, our principal discussion will revolve around commercial litigation, which we will get to in a bit. But before we do so, let's have a look at the other forms as well. Yeah, beginning with mediation. Mediation is the most informal method of dispute resolution. It is quite informal. It's less costly as well. It's very quick and painless. This deals essentially with a knowledgeable third party, often neutral, knowledgeable third party that gets involved to try and settle the matter. So whenever you have, for example, a very menial dispute between neighbors, let's say, where it might be in relation to some form of nuisance that has happened, some noise, or the dog often coming over the lawn and then dirtying the place, something like that. It's often not worthy of court time, and it will be far more expensive to go through court. So what generally a solicitor or what a solicitor should recommend is mediation, to have a third party counselor of some sort, a mediator. Might be someone in the community as well. And many communities in the UK have these personalities. Like a community watch, you'll have a head of a particular community watch that will look over these things. Mediation is less expensive, and oftentimes, because of human nature, people don't want to opt for it because it doesn't feel like a resolution has happened. It's more like compromise on both parts. But it's often recommended. Now, the speciality of mediation is that it relates predominantly to personal or individual matters. Very rarely, if at all, would you ever see mediation as an option for corporate disputes. What you would most likely see when it comes to businesses rather than individuals is parties opting for arbitration. Arbitration is something much more predominantly focused on trying to resolve disputes between corporate or business entities. Now, there are a number of reasons why this might be preferred. One of the fundamental reasons why it's preferred is actually because the likelihood of the parties involved in an arbitration, including the arbitrators, being experts in the field that relates to that particular dispute. So, for example, in terms of contracts, you already have pre-baked into the contract arbitration clauses when it comes to construction contracts or any type of engineering contracts. In fact, there is a regulatory body that is specialized and they specifically look through matters of construction, that there are different books and reports built called FIDIC contracts, for instance. The contracts themselves are built for construction purposes. So they're like templates. So arbitration is something that is not relatively new, but often opted for predominantly because of the chances of an accurate result and an amicable result being possible much easier than in any other format. Apart from that, another major reason, at least in an international context, why arbitration is preferred is the fact that it's very private. The fact that there is privacy built into it. Why this is important, especially for public quoted companies, is because their share price is very sensitive to litigation and news items that might happen. So if they were to pursue commercial litigation, the unfortunate thing is, one bad headline and their stock value will plummet. Stakeholders and shareholders will get nervous. People will, back out, and it can lead to some awful things happening to the company. So this privacy aspect is the second most prudent or most pertinent reason why parties go for arbitration. The third fundamental reason is it's like a halfway house between mediation and commercial litigation, in the sense that it's an acceptable remedy which is binding and enforceable by court. So the aspect of arbitration and a result provided by arbitration is accepted in a court of law, which means whatever decision you come to, you know that you can get it enforced. Mediation, not so much. Because in mediation, it's very informal. It's just a settlement. And oftentimes, statistically, mediations, unless it's for a very small matter, are rarely, if ever, successful. Now, all things considered then, as much as arbitration seems like a relatively good option to go with, it's a best of both worlds. It's fairly private. It's a binding result. You're sure that the parties listening to the matter are also experts in it. Unlike if you go to court, the judges are generally knowledgeable but might not be aware of specific nuanced things in a particular industry. The unfortunate circumstance of arbitration is that just like that of commercial litigation, it is also costly. Because not only in this context do you have to pay your lawyer or the solicitor and the barrister, but you have to pay the arbitrators, the 3-member panel that makes up the arbitration, the chairman and the other 2, but even the venue. And oftentimes this has been a criticism of arbitration, because the arbitrators and all parties involved are being paid. There is a unfortunate subconscious consequence that the delay becomes inbuilt and inherent, because most of the time arbitrations don't essentially get paid on a bulk fee. It gets paid based on sittings. So as such, the more sittings that an arbitration goes for, the more people get paid. So subconsciously, what you do see is, unfortunately, the thing that came about to prevent delay causes delay, and therefore is costly as well. So this has been an unfortunate circumstance. There have been a lot of regulations being put in England and Wales and other predominant arbitration-heavy countries like Singapore, for instance. The Singapore International Arbitration Commission, all of them have put places in where you have incentives for finishing early, as opposed to making people go on and on for months and years on end. Right. Now, again, at this stage, one thing we need to understand is, as a solicitor, there is a certain level of due diligence that has to happen in terms of a client. So when a client comes to a solicitor, comes to us with a particular requirement, says, here's what has happened to me, what's the best solution, in determining which way to go about it is basically on 2 fronts. One is the haste, or how quickly the client needs a solution. On the other hand, what remedy, at least financially, and how enforceable that result needs to be. So when a solicitor advises a client, if the client needs, for example, something to happen now, let's say someone is breaking a wall And because that person is breaking a wall as a neighbor, what has essentially happened is your house also, the integrity of your house is being compromised. So the likelihood of there being collapse is imminent. There can be danger to life, there can be danger to like property damage and cost that is entailed in that as well, which means you need an immediate result, essentially not a resolution, but an immediate result to hear things out, in which case you might need an injunction to prevent the person who's doing it to stop doing it, to start hearing the case. In which case, as a solicitor, the best advice you could give is to actually go for commercial litigation, because you need the strong arm of the law to stop someone from doing something. Then you can hear the matter. However, if it is something that can be settled, that can be quickly resolved, if it is not life threatening, if it is not something that will cause severe harm in that context, but you need a solution now, you need a resolution now, it is far better for a solicitor to advise a client to go for an ADR method. If it's a personal matter, mediation. If it is a corporate matter, arbitration, if there is no such clause in a contract at all. Most of the time there are, where there isn't. The reason I'm stressing on this is some questions in dispute resolution, I would say about 2/3 of the questions in dispute resolution are problem based. So they give you a scenario. So they will say, for example, Savitru is building his home. Nirav is studying for the examination and cannot continue to study because of the constant drilling. In order to get the building built faster, Savitru has commissioned a company that works through the night, almost 24 hours, 7 days a week. This is a problem for Nirav to continue to study. Now, in such a situation, he would want you to stop. So to get you to stop doing that, he would have to go the commercial litigation route. The better route would be the commercial litigation route. And if you have not been cordial enough to stop it after being asked. Now, those sort of things we will look at later as well, like what the court expects a litigant to have done before even approaching court in the first place.